Connie.
Okay, yes, I would actually like to make a motion at this time to take the annexation of the Jeff Wilson property that's on Highway 100 off of the table and put it back on our agenda for a public hearing at the next possible meeting. And I know in talking to Jim, we have to give 15 days of public notice. So the next meeting, I believe, would be February 7th.
I believe, yes. 7th, don't you think, Darren? Yeah, first meeting in February to the 7th.
February. Personally, I think this needs to be resolved. I feel like by tabling this issue, all we've done is give the impression that we're still interested and we're allowing Mr. Wilson to continue to operate illegally at this point. So I'd like to see it resolved. I'd like to see us
I'll second
get
that
it off
motion.
of our plates.
So we have a motion by Connie Groff, seconded by Rhodes, to take off of the table, bring back up the annexation on the east part of town, the Jeff Wilson annexation.
I'm assuming that means that the public hearing would be on that
The
7th?
Yes. And then
Okay.
you
At
would
the
vote.
earliest possible date, so that would be at our February 7th meeting, we would have the public hearing.
And then 7 days later, you, or again, 15 again? To have the vote on the annexation.
So we're gonna have a public hearing on the first Monday of February, and then the voting would take place on the first Monday of March.
Right.
Yes.
That's the motion. Okay, all those in favor signify by saying aye.
Aye.
Opposed?
Nay. It should be up to the developers to when they get their public hearing. And in this case especially, there's been a lot of circumstance along this issue. And I understand that the property owner and the property that's wishing to come into the city limits has asked that it be tabled until such time as they can get it worked out. And as an interpretive statement to say that the entity that's trying to come into the city limits is operating illegally, I question that, as that has yet to be proven in a court of law. As it stands to this date, the charges from the county have still been dropped against this individual, have not been refiled technically. And the facts that were presented to planning and zoning when it went to planning and zoning were such that at the time, the charges were dropped and weren't existent. Whether there was a statement made to Mark or somebody else that said these things were going to be refiled is irrelevant. The facts are the facts, and what's in black and white are the facts. To single out an individual as a result of a billboard being on a property that's surrounded by Washington city limits as an island of county inside the city it's hard for me to interpret as being fair to all concerned. There will be another issue coming up as it relates to other billboards inside the city limits that have not been permitted, and for one being the school district, the scoreboard / billboard along 47, off-premise signage that is on that particular billboard that's not been permitted. And we need to look at that, and there's going to be a whole laundry list of things that we may have overseen as a council to look at, but it's just my humble opinion.
Okay, well, by your vote, you've voted to bring this up at the next meeting of the February 7th meeting.